Excellencies, ladies and gentlemen, dear friends, it is a great privilege for South Africa to participate at this event, and as I've said before, we regard it as a matter of duty as South Africans to ensure that in the same way that we got support for our liberation, that we give back and support those that we were with in the trenches. I've shared before how I used to travel with women from Western Sahara. We were making speeches, rallying support for the anti-apartheid struggle. It therefore behooves South Africans to ensure that they also contribute to the freedom of the people of Western Sahara. There's nothing as potent, I've found, as a human rights-based approach to the question of Western Sahara, given that both covenants of human rights, the covenant on civil and political liberties and the covenant on social, economic and cultural rights begin with the same article verbatim, establishing the fact that it is inconceivable that you can enjoy any rights without the right to self-determination. Therefore, we are happy to continue with the work that we have been doing here in Geneva. However, my point of departure today, and indeed the theme of this side event, is General Assembly Resolution 71/103 and its relevance to Western Sahara, especially the exploitation of this non-self-governing territory by the occupying power and its economic proxies. Resolution 71/103, adopted on the 23rd of December 2016, states unambiguously that, I quote, any economic or other activity that has a negative impact on the interests of the peoples of non-self-governing territories and on the exercise of their right to self-determination is contrary to the purposes and the principles of the Charter of the United Nations. I wish to frame my presentation today with reference to three matters. The first is the Constitutive Act of the African Union with regard to the issue of self-determination. This is a principle that binds all members of the African Union without exception and which we are obliged to fulfill. As you will recall, the Organization of African Union, the predecessor to the African Union, had as its primary objective to leave no stone unturned until all of Africa had attained its liberation and was free from the shackles of colonialism. This remains the cornerstone of the African Union Constitutive Act. This is why, secondly, the communique of the Peace and Security Council of the African Union of the 21st of March 2017 urges the United Nations Security Council to address the illegal exploration and exploitation of Western Sahara's natural resources, and urges the occupying power not to enter into contracts for the exploration and exploitation of Western Sahara's natural resources. Thirdly, the 37th Summit of the Southern African Development Community, held on the 19th to the 20th of August 2017 in Tshwane, Pretoria, South Africa, expressed concern, and I quote, that colonialism on the continent is as yet to be eradicated, unquote, and approved the convening of a SADC Solidarity Conference with Western Sahara, with the outcomes to be shared with the African Union. Madam Moderator, I wish to be clear that I used to be clear about my use of the term occupying power. The UN has never appointed an administering power for Western Sahara. The territory is, in theory at least, under the protection of the United Nations. Western Sahara is therefore under illegal occupation at international law. Turning now to the heart of my presentation, it's a matter of considerable pride to South Africa that on the 15th of June 2017, the Eastern Cape Local Division of the High Court of South Africa delivered a precedent-setting judgment. This comes in the wake of the judgment of the European Court of Justice of the 21st of December 2016, stating that, I quote, Western Sahara has a separate and distinct status in relation to that of any state including the Kingdom of Morocco, unquote. At question in the South African court case was a cargo of phosphate from Western Sahara that had been mined in the Bokra mine by a Moroccan company and was en route to New Zealand aboard the vessel NM Cherry Blossom. After the vessel docked at Kucha, on the outskirts of Port Elizabeth, the Sahrawi Arab Democratic Republic and Polisario Front brought an application to interdict the cargo. This was duly granted. The acting judge president of South Africa then constituted a full bench to hear the matter. In outlining the parties on the issues, the High Court of South Africa referenced Article 17 of the SADR Constitution, which holds that public property belongs to the Sahrawi people, including the mineral wealth, energy resources, underground wealth, territorial waters, and other resources defined by law. The court further referenced the 1975 judgment of the International Court of Justice, which stated that Morocco and Mauritania did not have territorial sovereignty over Western Sahara. It also referenced the 21st December 2016 judgment of the European Court of Justice. The South African court therefore firmly situated its judgment within the existing corpus of international law and court judgments pertaining to the status of Western Sahara. Turning to the ownership and exploitation of natural resources, the High Court noted General Assembly Resolutions 1514 and 1803, particularly Article 7 of the latter, which states that, I quote, violations of the rights of peoples and nations to sovereignty over their natural wealth and resources is contrary to the spirit and principle of the Charter of the United Nations and hinders the development of international cooperation and the maintenance of peace, unquote. The High Court then stated that the phosphate on board the NM Cherry Blossom had not been mined with the consent of the Sahrawi people, and that those, I quote, who may benefit from the mining of phosphate are not the people of the territory, but more likely Moroccan settlers, unquote. In examining whether the requirement of an interim interdict had been established, the High Court found that, I quote, sovereignty over the cargo of phosphate is vested in the people of Western Sahara. In other words, the people of Western Sahara own the cargo, unquote. The court upheld the argument made by the applicants that the phosphate was exploited without consultation with the people of Western Sahara and without their consent, and that they did not and would not benefit from its exploitation. The High Court then turned to the question of jurisdiction. In other words, whether a South African court could even hear the case. It pointed out that in terms of Section 232 of the Constitution, customary international law is automatically incorporated into South African law. Noting further that when interpreting any legislation, every court must prefer any reasonable interpretation of the legislation that is consistent with international law, unquote. The court then proceeded to find that the occupying power was not a party to the proceedings and had no proprietary interest in the matter, hence any claims to state immunity could not be upheld. The court's conclusion was as follows. 1. The cargo of phosphate be interdicted and the respondents restrained from removing it from the port. 2. That the vessel's registration documents and trading certificates be removed. 3. That in the event that the applicants obtain a final order for delivery and or possession of the cargo, the guarantor shall pay the applicants the market value of the cargo. 4. That leave is given to the applicants to sue the respondents for delivery of the cargo and further relief. Madam Moderator, this landmark judgment has profound and far-reaching implications. For the first time, a South African court, no less the High Court, has delivered a judgment that creates legal precedents in terms of resources illegally extracted from Western Sahara and passing through South African territorial waters. Where court applications are made in future, such cargo will be interdicted. The South African judicial system has breathed life into General Assembly Resolutions 1514, 1803, 71/103, and sent a clear message to South African and foreign companies that the illegal exploitation of the resources of Western Sahara now has serious consequences at South African law. Secondly, by situating its judgment within the corpus of international law, constituted by the advisory opinion of the ICJ of 1975 and the 2016 verdict of the ECJ, among others, the High Court has firmly aligned South African jurisprudence with the international legal position on Western Sahara, and may be the first, or one of the few exemplary cases of the implementation or operationalization of the advisory opinion of the ICJ of 1975. Categorically stating that sovereignty over the natural resources of the territory is vested in the Sahrawi people, not the occupying power or its economic agents and proxies. Thirdly, the judgment of the High Court reaffirmed the right of the Sahrawi people to self-determination in line with the UN Charter and numerous General Assembly resolutions, stating that the occupying power has no legitimate claim to sovereignty over Western Sahara. Against this background, Madam Moderator, my government is clear in its position that Western Sahara is and has for over 40 years been under the yoke of an illegal foreign occupation. The plundering and exploitation of the resources of Western Sahara is illegal under international law. This plundering prolongs the subjugation of the Sahrawi people, retards their development, and compromises their ability to exercise their right to self-determination. This exploitation takes place without the free, prior, and informed consent of the Sahrawi people, given that the Polisario Front, which General Assembly Resolution 34/37 of 1979 recognizes as the representative of the Sahrawi people, has no say over the territory's natural resources. This too is illegal and unacceptable. South Africa therefore calls on all member states of the United Nations, as outlined in Resolution 71/103, to put an end to the any economic activities by their nationals and businesses that are detrimental to the interests of the inhabitants of the non-self-governing territories, and to respect and safeguard the permanent sovereignty of the people of Western Sahara over their natural resources. It remains our firm belief that Western Sahara will be free in our lifetime, and that the blight of colonialism will be removed from our continent, and we will all be free. I thank you.